Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking, your YouTube channel brought to you by Aitken Robertson. I'm Melanie van Orde, your host and paralegal at Aitken Robertson. Today we are diving into the process of changing release terms when facing criminal charges alongside Counsel Richard Aitken. Hi, Richard.
Hey, Mel.
How are you?
I'm doing fine. Yourself?
I'm doing well, thank you. So, Richard, someone has been arrested and they've been released by the police. They are given certain terms that they need to abide by. How long do these terms usually last for?
Well, it lasts for a lot longer than most people think. We've had many clients who think that the release terms only last until their first appearance, and then it ends. Not the case. So the release terms last until the charges have been withdrawn, the accused has been acquitted, or has been sentenced, or if they've been changed.
So, Richard, what are the first steps that need to be taken when someone wants to vary these conditions?
The lawyer needs to look at the release document and see the nature of the release, whether it's an undertaking or what basically it's bail.
And is there a difference between varying release via an undertaking or a bail release?
Sure. An undertaking is what's given by the police at the police station. The accused signs it and is bound by the terms. On an undertaking, it's fairly easy to change, assuming there's a good reason for a change. Often there is. The defense lawyer negotiates with the Crown attorney. There's a document prepared. The lawyer for the accused signs it. The Crown signs it and it's filed with the court. There's no actual court appearance. The date and time of when the document is submitted to the court electronically determines when the term has actually been varied. So you can't rely on the variation ahead of that. You have to basically follow the terms until the lawyer's actually said, we filed it, you're good to go. On the other hand, if it's a bail, also you can do a negotiation with the Crown attorney. And again, most Crown attorneys are reasonable. And if it's a reasonable request, generally speaking, they will agree. However, if it's not possible and the Crown will not agree to the proposed change, you have to do what's called a bail review, basically, which is done in Superior Court. It's complicated, it's expensive, so where possible, you want to try and change the release terms on consent with the Crown attorney.
Richard, in your experience, what are some problematic release terms that you found?
Sure. I think what the police really need is a template of approved release terms that historically have worked well and did not need modification. Where I often see it is in domestics, where there are terms that restrict or prohibit contact between the spouses, usually the person who is the accused and the person who is the alleged victim. However, often the police don't think about the practicalities. Who's going to bring Johnny to school or Joan to music lessons? Who's going to pay the mortgage that month? Who's paying this bill or that bill? Often communication is required. And everyone suffers if there's not the right kind of communication. And it's in everyone's benefit if something is done to change the status quo, so all that can take place. So that's a good example. Another one, perhaps two people working in the same business, and they're going to have indirect contact just by passing each other in the corridor. Again, most Crowns in reasonable situations will agree to make some allowances and changes to try to prevent a breach situation.
How long a variation can take?
If it's a really important variation and it relates to an undertaking, sometimes the Crown will get it done same day. However, that's a bit optimistic. I think in most cases, you're looking at a few days to a week for something which is a variation of undertaking. Something relating to a variation of an actual bail term often takes longer. I would say more likely a week or two. That's assuming you're negotiating. Ultimately, the change is done in court, virtual court, but still the accused needs to be there. The surety or sureties needs to be there. And of course, the Crown is done in a court sort of setting. If it's a bail review, much longer. Different documents have to be prepared, a transcript of the evidence of the bail hearing, affidavit from the accused and surety, and so on. You're looking at more like a few weeks to a month.
Channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.